We have allowed the appeal, but more than that, we have dealt with substantially about the. We have allowed the given opportunity to examine, but the problems relating to registration in our country. We have, so I just read what we have done. We have asked the law commission to also to look into it. We had this, we have allowed the given opportunity to examine, that is the registration problems relating to registration in our country. And we have, so I just read what we have done. We have asked the law commission to also to look into it. Registration. We had this, we have allowed the given opportunity to examine, that is the registration problems relating to registration in our country. And stand back. So I just read what we have done. We have asked the law commission to also to look into it. Registration. We had this, we have allowed the given opportunity to examine, that is the registration problems relating to registration in our country. And stand back. So I just read what we have done. We have asked the law commission to also to look into it. We had this, we have allowed the given opportunity to examine, that is the registration problems relating to registration in our country. And stand back. So I just read what we have done. We have asked the law commission to also to look into it. We had this solution to the problems created by the existing system of registration. Then we talked about technological advancement and how we could utilize the blockchain technology for the purpose of registration so that we can move away from a presumptive titling to conclusive titling. This is what the country now has to move further. And we have suggested that the blockchain technology, so that once you register an immovable property, you should know that it is a conclusive proof. Instead, we know the kind of problems that we have about registration. You register your documents, immediately a suit is filed that it is the sale deed is illegal. So therefore, we have suffered this for about 70 years. And we thought that now the time has come with the advantage of technology to move forward, and therefore directed the law commission to examine this, taking into account other stakeholders, that is the states and other departments. Otherwise, the case is decided on the merits of the matter. The importance is about our direction to the law commission to examine this position.
The larger issue.
Otherwise, we have allowed the appeal.
Obliged.
Thank you.
It's 2 weeks. It's 2 weeks after the 14th of July. This matter was to be listed.
Sorry?
It's on 14th of July 2025. Lordship directed to list the matter after 2 weeks.
It's an SLP stage?
Yes.
Okay, we'll list it first.
See, it's
We'll give a date.
okay.
No urgency.
My difficulty is this. In this matter, the government is promoting the lateral appointees over the meritorious candidate.
Right, you made your
Any
next.
so good.
May I please, my lords?
27th, it's coming. 24th,
24th, my lords. Yes.
not to be deleted.
Obliged, my lords. With my lord's permission, I seek to mention the matter at item 47
Yes,
today.
what is it?
My lords, the joint request for adjournment since there's a possibility of settlement in the matter.
When is it listed?
It's listed today, my lords,
What?
item 47.
Mention it. It's called. The big urgency.
We'll do so, my lords.
May I please, Your Lordships? Well, it's the connected matter. Your Lordships have given a date of 16th December.
Post along with that.
Well, it's notice requires and
In other
permission to.
matters, notice has gone.
Yes, sorry, Malaj.
In other matters.
Yes, yes, Malaj. Yes, yes.
Issue notice, post along with that.
And permission to serve the standing council.
Sure, sure.
Grateful.
You know?
Grateful.
When anything, tell me. I'm not sure.
Your Lordship, this is my application seeking stay against the execution proceeding pending before the NCDRC. Your Lordship, the impugn order directs me to deposit a amount.
Go right.
Milord, I appear for
It's an
the.
IA.
Please, Your Lordship.
Okay.
Your Lordship, the impugn order directs me to pay a compensation of ₹2 lakh to the respondent number 1, and further directs the respondent number 2 to release to refund the entire amount deposited by respondent number 1.
Why should we grant a small amount only?
Please, Your Lordship, the concern is that the impugn order directs the respondent number 2 to refund the entire amount deposited by respondent number 1. However, it has not been clarified by the commission that whom this amount has to be refunded. Your Lordship.
Yes, it is directed to be paid to me.
Your
I
Lordship,
am the home buyer. What happened? I I bought,
But if I may
payments-
be
and that is a
permitted,
decree
Milord, I-
against to final pursuant to.
Wait a minute.
Milord, if I may be permitted, I am Milord, my learned colleague.
Okay, come,
Milord,
come.
Milord, I am the bank
You're for
from,
the consumer.
I'm for the bank, Milord, who has filed this appeal. I am the appellant in this matter, Milord.
Oh.
Milord, I had given a loan. Now, the tripartite agreement says that in case of cancellation for any reason whatsoever, the amount that has to be refunded has to come to me. Milord, it makes sense because I'm the
Doesn't
one.
matter.
No,
You have lost in the high.
No, Milord, the order only says amount has to be refunded. If the operative portion may be seen, Milord, the order does not specify to whom it has to be refunded. Because this amount, Milord, logically has to come to me because it has gone from my pocket.
How much is
That's-
that? That's the.
Milord, 2 crores is the amount that I had sanctioned, Milord. 1.68 is what I had disbursed. Milord, with the interest which has accumulated as on January 2023, it is in excess of 5 crores. Milord, they have deposited.
The direction is for.
Milord, may kindly see.
For refund only.
Milord, the direction is for refund. All I'm seeking is a clarification regarding whom that refund has to go to. That is all, Milord.
It's to the consumer.
Yes.
Milord, it cannot be. Milord, may kindly
The
see the.
complainant.
Can I
Milord, may
clarify?
kindly see the tripartite
Can I-
agreement for a minute, Milord.
They are making two misleading statements. What happened? I filed consumer complaint against 1 and 2, the appellant, because I'm here also, I'm the appellant. I have come against the award of only 2 lakhs
2 lakhs.
as against the bank. In that notice were issued, then they filed a delayed appeal and got tagged with my appeal. That's one law. Secondly, the decree is passed against the builder
Correct.
and the bank. The builder has not challenged the decree, has agreed with decree and deposited the amount. I am seeking withdrawal of that amount. Now bank is saying that don't disburse that amount. I have a claim for which they filed a DRT proceeding and civil proceeding. I have already refunded the substantial part of the loan to the bank. How can they seek in these proceedings my fund of money to me?
Garnish.
Milord,
It's
may
a completely,
Milord, may permit me,
Milord,
Milord.
Dismissed, IAD.
Milord, may permit me to just,
Right.
Milord, may give me 2 minutes, Milord. I would just.
The appeal is, while we are not inclined to grant an interim order, the disbursal of the amounts will be subject to the final
Milord,
outcome of the appeal.
Very good.
Can I say
For the
Will
developer.
be out subject to the
Milord,
outcome.
as
I am
far
for the
as
developer, please 1 second, sir.
You're for the-
I am for the developer, respondent number 2. Your Lordship would see page 15, para 13. They have themselves admitted that whatever the controversy between them, I have deposited the amount in the registry of the NCDRC and the NCDRC has passed an order to.
It's all right. How are you concerned? If
No,
it is-
that is
deposited the
incorrect
money.
statement is
Yes.
being made that
it's all
Milord, it may not be released, Milord,
No.
till the appeal
they have
is.
taken out
subject to-
proceedings. They have not been
Same say
successful.
we
in
passed orders. That's enough. Next.
Milord, may I only make one small submission? Milord, I was a secured
You are
lender.
re-arguing the case. You have already
Milord, may
passed
give me only 1 minute
they
to
have
Milord,
lost
say
to
this.
the commercial court.
orders.
Milord, this is a
It's already-
cancellation done by them, Milord. Milord, I'm a secured lender. I have today become unsecured by virtue of their cancellation of allotment.
You are in appeal. You'll hear the appeal. And it will be what you are.
Milord, I may
They have
become
succeeded
unsecured and
in
it will
the
be
lost in the
difficult
High
for
Court.
me to.
National Commission, when we admit the matter, we normally admit first appeals and we'll give you an opportunity to argue. Otherwise, consumer matters, many of them will get dismissed, but we'll give you
Milord,
an
may-
opportunity.
in that case, may I
But it
request,
will be subject to the outcome of the appeal.
Milord, in that case, may I request that a date may be given, Milord, because the execution proceedings are pending, Milord.
Hearing
A
expedited.
date may be given. Milord.
Deeply.
Hearing expedited, that's all. Nothing. Right? इसको अपलोड करवा लो सबके पास
Your Lordship, I'm seeking passover in this matter.
yes pass over delay है बहुत
Wait, please, Your Lordship. Lords, I appear for petition item 4, my lords. I understand, Lords, I have lost at 3 places. My lords, there's only one submission, my lords. The suit that was filed by the respondent, my lords, was barred in limitation, my lords. He's seeking the limitation that he has joined my suit, my lords. He should have ideally filed his suit in year 1974 when the sale deed was executed, my lords.
concurrent on course
I understand.
thing remaining
My lords, delay may be continued.
delay control SLP dismissed
Item 5.
इसका क्या आपका क्या है इसका इनका petitioner says
Please. Okay.
There's a letter.
There is a refiling delay that
Six, there is a letter.
My lords, I appear for the petitioner. My lords, this is a matter where in the year 2000, I got a decree in my favor for possession. My lord, subsequently, the other party demolished the house and then gave a false statement before the Honorable High Court. The contempt petition was initiated. It went on for almost 25 years. And my lords, the High Court dismissed the contempt petition.
And so why you contest all cases on the basis of contempt? This is becoming, huh?
Well, in this case, there is a peculiar fact because I was dispossessed. The other party kept on giving statement on affidavit that in case we succeed, we will restore the house and we will rebuild it for you. My lord, and now at this point in time, after 25 years of battle, the legal battle, my predecessor in interest, father had filed this suit. He passed away. I went on with this suit. It is still ongoing, my lords. And now the Honorable High Court has exempted them on the basis of an unconditional apology. My lords, the difficulty before the...
That in contempt.
My lord, I agree that it is a matter between...
Thank you.
My lords,
Dismissed.
my lords, only on this point that for the past 25 years, the parties have
But
been
you're
litigating.
getting through contempts like this. We said that court, unless
So the court
deliberated
had
to be-
suo moto initiated the contempt petition, my lord. 25 years, nothing has happened, and at this stage, I have been left remediless, my lord. My lord, I got a...
It is not through contempt.
My lord, I got a decree. Nothing happened to that. The contempt was initiated by the court itself. Suo moto contempt proceedings were initiated by the court. And my lords, I'm not getting anything out of this 25-year-old legal battle. And what happened to that decree which was issued in my favor, my lords?
Right. Thank you. We dismiss it.
My lords.
Next.
On the 6th for the Passover, Your Lordship.
Respondent,
Yes.
do not vacated the premises. Undertakings to give and anyway pass over.
Obliged.
My lordships have dismissed a
The
similar,
matters we have
while
discussed.
keeping the question of law open. I request to pass it, my lord. Much obliged, my lordships.
Again, same Rajasthan.
Lordships had already indicated that it should not have been filed. All of these were filed in August. They could not be listed because they were lying in defects. But let me just pass the same order. I'll just pass over them.
Your Lordship, item number 52 and 60 are connected with this.
So they are similar, my lords. All of them came to be filed because batch of petitions came to be listed in Rajasthan.
Why do you give a list of all those which are pending?
Actually, most of them got listed in one go. There were few that were left in defects.
Yes, you may.
So therefore, they've been coming up.
All right.
Apologies. my lords.
All right.
Same order.
My lord, this matter, the suit was filed in
That's the
1980.
claim you filed after so.
My lord, the only reason, my lord, the only reason, my lord,
2010 counterclaim you filed in 2016.
I bought it. My lord, what happened? The original suit was in 87, my lord.
Correct.
That only the suit was decided, counterclaim was not decided, my lord. Ultimately, it was remanded back by the High Court in the year 2000, my
You
lord.
know that.
My lord, what happened? I filed a single appeal. Technically, my lord, didn't challenge the counterclaim. I only challenged the suit appeal. The appeal was only in the suit, not the counterclaim, my lord. The learned ADJ, on a technical ground, because I have not assailed the counterclaim, dismissed the appeal. The High Court also observes that you have not.
You do it at least immediately after the At least in the first appeal stage when it was decided in 2013.
My lord, I filed a SLP before this honorable court. We withdrew it, my lord. And ultimately, I gave the advice that you have to challenge the counterclaim. My lord, immediately he challenged it. And my lord, that was the only reason. My lord,
Dismissed.
my lord, the reason being, my lord, only,
Thank you, thank you. No,
my lord, it's 87 suit, my lord, and getting contested, my lord, only on a hyper-technical ground, my lord.
can't be done.
I'm grateful.
May please, your lordship. My lord, the document which is admitted by, it is written by the successful resolution applicant, my lords, to the COC, which has a
How 227? How
The
do you
plan is sanctioned
my
by the
227 because I filed an IA 25 before the NCLT, which was not heard because it was not heard on many. On,
given 2-3 judgments on this?
Yes,
matter?
no, my lords. No, my lords.
Court can't interfere.
No, High Court. My High Court could have then said, "I am not interfering." High Court goes on to hold that I have no right to be heard, my lords. That's a problem because High Court does not rely on.
As long as it doesn't interfere,
But
whether
but
it holds it as a right to.
because thereafter, my lords, when the IA that I filed before NCLT was in fact taken up, the NCLT says I cannot do anything because there's already a High Court order. The writ petition has already been dismissed.
Sorry, dismiss.
May I only say this, my lords, that now what has happened is that the plan has been approved. My appeal.
Go to IBC.
Yes, yes, my lords, all those matters are already pending before NCLAT.
Go there.
My,
this
no, no,
point is
my-
taken by them.
only,
Can clap.
I only want to say,
What is the need?
Sorry, Manoj, I'm sorry. Extremely
I only want to say that this letter of 30th June, my lords, has some relevance. I may be this may not come in the way of me
Make your choices. Thank you.
no, my lords will then say that
Dismiss,
the writ petition, my lords,
Word, not a word.
Please,
Thank you. Dismiss.
this will not come in, my lords will say that this will not come in the way of
Nothing. You make your choices.
Lordship, please.
then we'll withdraw,
Dismissed is withdrawn.
we'll withdraw this writ petition,
Dismiss is
this SLP, my lords, that
Sure,
would be
sir.
better.
Please, sir.
Obliged, my
That we will permit. There are already matters pending.
Yes, my lordship, there are a lot of matters are already pending, but the issue is totally different in the way that they are not investing any penny on the purchasing of,
For publicity like this.
my lordship, today we are having a
Court is
AQI.
already monitoring. Are you aware or not aware?
Yeah, sir, I'm aware, sir, but the problem is
You
that,
are just gaining publicity. That
no, sir, I have not.
Then-
I am totally alone standing here. I have no interest in publicity.
You are appearing as an advocate or what?
As a party in person, sir, myself is an advocate.
You're wearing your bands. And all.
I'm sorry, my lordship.
What do you mean sorry?
This is not for any public.
What do you mean sorry?
Sir, just because I feel
No,
myself,
at least the basic principle. Man, you
I-
are
I will
appearing as a party in person and you are appearing before us as an advocate.
I'll remove my
You
band.
don't permit this.
I'm sorry, my lordship, pardon.
Dismissed, dismissed. Next. Yeah,
These are those matters listed before another bench listed on 10th of November.
Yeah.
Yes, Manoj, I have passed on that order.
All right, we'll post it along with that.
Notice, Manoj.
Notice.
Obliged.
sister.
Obliged.
There's a delay here,
Uh,
as usual.
Manoj, the batch
No,
is
this
pending.
batch you gave that list, right?
Yes, my lords, but it is before another bench. That is a different matter which is before my lords. That is a different batch.
See, this is a. Anyway, chalo, ठीक है.
My lords, before my lords, it is restriction of arrears.
I appear in the other matter which is listed before the other bench.
Yes.
My lord, there are three.
They are without any application of mind, these matters are getting accumulated. We just file, now that you think it's an incentive for the union. Because similar matters are pending, the moment the matters come, you just file lock, stock and barrel.
My lords, may I say from the similar
it's,
impugned order, leave granted, matter dismissed.
Correct?
They
Shows-
suppress that.
Shows that order.
I don't have a copy. I'll show.
My lords, all that
All
was
that is
also
suppressed.
discussed.
All that is suppressed, my lords, before the other two. The matters are heard by three benches. One bench, my lords, has taken a view, granted leave, passed a reasoned order. The other two benches, they don't disclose this reasoned order. I'll take a pass over, my lords, and pass.
Well, it's
Give
we
the
had
copy of that.
discussed, well, I say
Where
this
did you
with,
disclose to us?
well, it's not here, before the another bench where they are saying that another matter was
Then
dismissed.
also I was
He had,
gave you
he was
attention.
there, Malaj, he was heard
Those
by the
matters
another
are
bench.
clubbed together. at-
Yes, yes, and he was heard before the another bench as well. He posed this same.
Notice, we'll just post it. Which bench?
Let it be posted, Malaj. It is before
Malad-
Justice Pankaj Mithal, Malaj.
Post before that.
The list for Monday is out. It's not in the list.
Sorry.
The list for
However,
Monday.
we will post it along with that.
Okay.
Post along with.
Malaj. Obliged, Malaj.
Yeah, please, Malaj. Malaj, yeah, Malaj, the surveyor, Malaj, restricts my claim to 9 days of loss and
First appeal, no? We'll issue notice.
grateful. Malaj. So there's a delay of 34 days.
Refiling or regular?
For filing, regular filing. Malaj.
Notice.
Grateful.
Admitted, appeal admitted. Notice issued, appeal admitted.
Item 15.
Lordship, I am appearing for the petitioner in this matter. Lordship, similar issue is already pending before this honorable court in civil appeal number 9980 of 2016.
Notice post along with such.
Lordship, one more thing I need to mention. Lordship, in previous matters, there was direction of this honorable court to deposit the entire amount with the learned lower court. But in these cases, we have already deposited the entire amount with the lower court. So there is no need to pass such direction, Lordship.
Learned counsel for the petitioner says that the entire amount under the award, right?
Yes, Lordship.
The award has already been deposited. Full stop. The said deposit shall continue pending disposal of the special petition. Issue notice Karlena Pal. Post along with so.
Lordship, delay may be condoned. There is a delay of 37 days in fact.
Okay, notice. Next.
Oblige.
May I please, my lord? My lord, the two applications, my lord, were allowed by the trial court, my lord. My lord, the High Court, my lord, in exercise of jurisdiction under 227, my lord, as my lord.
Look at the section. No? Section says the judicial proceedings, and High Court interpreted. And there
Very well.
Item 17.
My lord, may consider staying the proceedings. My lord.
spiced.
Very well.
Only evidence.
Oblige.
Dusty in addition. Take out dusty notice and serve them.
Very well.
We will dispose of on the next date of hearing.
Very well.
May I please, your lordship? My lord, the land was taken possession of without any acquisition or compensation in 2017.
To challenge the main order.
No, my lord, your lordship may kindly see
What
page
happened to 10th of September
120.
2024?
My lord, nothing, my lord.
Then?
No, my lord, just see page 128. My lord, when they did not pay me compensation, I went to the High Court. Then that order is at page 128. They calculated.
Cases are being conducted. Janani,
My lord, let me
we are,
just.
Janani, your problem. We'll hear you.
My lord.
We'll hear you. But what we are saying is that the earlier direction is for them to pass appropriate orders. Correct us if we are wrong.
Yes, my lord.
And on the ground that they have not passed orders, you have initiated contempt. Now the High Court has dismissed the contempt because orders are passed. Order is of 10th of September 2024. That's where your remedy lies. You must challenge that order.
No, my lord, your lord.
To that. What is the order?
Of which
you are
contempt?
saying? 1 minute. What is the order which you are saying is deliberate disobedience? Shows
Yes.
that order.
That is at page 128.
Date of that.
Date is 3rd July
Correct.
2023.
Exactly. Open up and then read
Yes,
that.
128.
What is
No,
the-
my lord, what is my prayer at page
Read that, read that.
129?
See the direction in the.
Yes, my lord, I'm coming. Page 129, my lord. I'll just give me 2 minutes, my lord. The second last paragraph, the petitioner in the writ petition has sought a direction upon the state respondent to assess compensation in respect of the entire 11 decimals of land in terms of the right to fair compensation and transparency in land acquisition, etc. Act 2013. Now the operative portion of the judgment is page 130, second para. Strangely, the said compensation was assessed in terms of the government order dated 21st July 2005, though the land was utilized in 2017. This is what I challenge, and this is what the High Court says even now.
And-
Then my lord, I'll just complete. The petitioner seeks compensation in terms of this. Then 131, operative portion, second para. Upon consideration of the submission made on behalf of the party, the court is inclined to hold that since the petitioner claims compensation in respect of, this is about the extent of land, then my lord, 131, I'm sorry.
Page 131, just see what it.
Last line, my lord. Upon receipt of such report, the fifth respondent shall take necessary steps for assessment of compensation payable to the petitioner in terms of the Act of 2013 and in tune with the market value of the plot in question as in 2017. Now, your lordship may kindly see the impugned judgment. Why did I go? Because they, in spite of this specific direction, that compensation has to be as per the 2013 Act and 2017 rate, what they do. Now, your lordship may kindly see what the High Court says.
Page altogether. You are
No, my lord, High Court.
on trip, I should say.
My lord, page 3. Page 3, High Court.
This petition is
My lord,
post
page-
off. Before that, you haven't completed reading it.
I'm sorry, my lord.
This page 131, the direction is to pass orders.
Yes.
It may be a wrong way of passing the orders. They may not have complied with the direction, but they passed orders on 10th of September 24.
My lord, it is not a simple compliance, my lord. The compliance has to be in the spirit and in terms of the order of the court.
So therefore,
The order of the court.
wrong compliance of the directions of the High Court in 10/9/2024 is a case where you will writ petition, if you file against that, that will be allowed.
My lord, and allowed and
In a
what would
simpler
be
thing than
said?
this.
Allowed and what would be said? No, you should, we had earlier in 2023 directed you to calculate compensation as per 2013 and 2017. You have wrongly calculated as per 2005. Well, again, they will be repeating the 2023 order. Page 3, my lord. My lord, lordship, may kindly see
There
page.
is no willful disobedience of the direction.
My lord, it is a willful
3/7/2023.
disobedience, my lord.
However, we make it clear that the petitioner will be entitled to challenge the consequential order passed by the respondent on 10/9/2024 by filing a writ petition or any other appropriate remedy or by invoking any other appropriate remedy. We also make it clear that the observations made by the High Court while disposing of the contempt petition will not come in the way of deciding the said writ petition. To challenge that,
My lord, may at least, my lord,
clarified.
possession is taken and no compensation, no acquisition.
Unless you challenge that,
No, my lord.
how will you?
My lord, but your lordship may say.
Okay, we have passed orders.
My lord, then at least direct the High Court to decide the matter
If such petition
expeditiously.
is
my
filed,
lord.
it shall be, if such a petition is filed, it shall be disposed of expeditiously.
Obliged.
My lord, this is covered matter. In the this is covered matter by the reportable judgment passed in SLP number 17013 of 2014. Citation is 2025 SSC online SC 899.
This is again, contempt is dismissed. Covered by what judgment is this?
Yes, my lord, in the similar circumstances, Honorable Supreme Court has remanded back the matter to the single bench of High Court. In fact, the legal position in both the cases is identical, my lord. Not similar, identical.
This also arises out of a contempt?
Yes, my lord. Kindly have page number 7 of the judgment passed by me.
Okay, anyway, we'll issue notice. Learned counsel for the petition has brought to our notice an order judgment passed by this court in Ranjan Chandra and others versus Sanjay Arora, civil appeal number so-and-so, dated so-and-so, and submits that the issue arising for consideration is covered by the said judgment. Issue notice.
Obliged.
We'll hear it.
May it please your lordship.
Lordship, against the same impugned order, this Honorable Court has issued notice in SLP 19.1 and 19.2 arise out of the similar issue, my lord.
What is this about?
My lord, this is about the contractual assistant professors working in the state of Gujarat. Arrears of their back.
Issue notice.
Very well. My lord, there is a delay. Your lordship may issue notice on delay as well.
Issue notice.
On all three, my lord.
Sure, sure.
Very well. Deeply obliged, your lordship.
Not the same impugned order is challenged by the company. Not this, it's the same impugned order, no difficulty. But this is a matter where that notice was issued not in September, August. They went to the ID court and Extra 20.
Correct.
They filed a substantive petition. When it was rejected, then they have come here. So I don't know whether your lordship would like to.
It is not.
It is not.
No,
it's there on record. An Extra 20. Just see an Extra 20.
That also we only issued notice.
No,
My lord, after the
that.
after the notice,
ID court after this.
The same impugned order. We'll take it up together.
my lord, yes.
Then have it not some day together, sir, so that
Sure,
this
sure.
can be what is happening because of the pendency of this now, Lord, they will create more problem for us.
Yeah.
No. Not the only thing is, they assume they are taking, the High Court has expedited the matter.
To notice post along with that.
My lord.
Uska, any date in that?
Yes, 12th is the date. No, sorry.
No.
In that there is no date.
Other matter, is there a date in that?
No, Lord, there is no date in that.
Date.
Any date, your lordship will fix them some date.
Fix some date.
Very well.
Thank you.
We are the only respondent, so we are accepting notice.
My lord, the matter which
Who
is
is taking-
expedited,
Advocate on record.
my lord, the stay in that matter need not be considered as stay to the proceeding, because there are two, for the employer two.
Stays of the only High Court order, not of
Yes.
the proceeding.
Passing any interim.
My lord, yes, obliged.
Deeply,
Just post along with that. We'll
That's-
see later.
deeply obliged.
My lords, petitioner has preferred this SLP for seeking direction of this honorable court to wo- my lords,
High Court has listed.
my lords, from 1.5 years matter was not.
This court has been dismissing SLPs against adjournment orders with costs. How much cost you want us to impose? Tell us. Just an adjournment orders.
My lords,
The case is
I am 65 years of age. My lords, if any delay,
dismissed. Next,
my lords, kindly allow me to withdraw.
withdraw. Dismiss this withdraw.
Obliged, my lord.
Letter, as per the letter. मैं बोल रहे थे हम dismiss
My lord, the plots in questions were allotted in 2003, my lord.
23.
The appeal is pending for last 12 years, my lord. I may be allowed to move an application for early hearing, my lord, so that it can be expedited, my lord.
It's as per the roster.
For last 20 years, my lord.
Why is it that indiscriminately against adjournment orders, the High Court has said that listed, just what does the side?
My lord, it is coming in roster, my lord. That is a difficulty for last 12 years, my lord.
Look at the order in registry is directed to list the appeals as per roster.
Yes, my lord. And for 12 years, my lord, it is pending.
Order for you.
The only request is, my lord, that I may be allowed to move an early hearing
With
application.
costs quantified at
My lord, I may be allowed to, please, my lord.
25,000.
My lord, I am extremely sorry, my lord, please. I am suffering, my lord, for last 22 years.
Everybody, sir. Anyway, doesn't matter.
Application, my lord, I may be allowed to,
What withdraw?
I'll withdraw, my lord. Then, my lord, the only request is, my lord, that I may be allowed to move an early hearing application, my lord.
Do what you want.
That may be recorded, my lord.
Next.
Much obliged.
Lordship, state appeal was allowed in absence.
2013 days delay.
Lordship, because kindly come to page 31.
That amount is not enough for you.
No, immediately we filed it. Kindly come to page 31, Lordship, the last part of the order. Since it was disposed of non-appearance, state appeal, in view of the, however, if agreed party's order, it will be open for to file application.
1994 order.
Granting order. Now, immediately, Lordships, we filed a review that is at page 96. But page 96, review, similar matters are pending, your Lordship.
That is by the state, not by the individual.
By
On the principle, you are mistaken. We checked that order. those are not cases where individuals have filed, where the state had policy was interfered
but-
with.
One matter, I had filed this petitioner.
Anyway, not condone the delay.
Let's say this petitioner had filed one matter, which that was also admitted and tagged with other matters. Now, Lordship, kindly come page 96. Page 96.
What is this?
Page 96.
What is this order?
Office report. Office report says.
Shows the 2013 days.
Lordship, kindly come to page 96. Opportunity was given to us on 2019. We filed review. The court says review. High Court has got no jurisdiction for review.
Doesn't matter. Review main order is 2019 order.
19 in order, Lordship, page 31. Opportunity was given to us because kindly come to page 3. Page 3, Lordship. Page 3 of the order. On the heading, non-appearance of the parties.
That's we understand that.
Lordship.
You quoted the entirety of the Supreme Court order.
Lordship.
But then why did you take so long?
Lordship, we immediately within 1 month we filed review as per the opportunity given by us on page 31. Page 31, Lordship, kindly come to last para 3. Page 31. Opportunity was given to us to, it will be open for to file application within a period of 30 days for revival of these respective appeals.
Admission. But what do you say about the merits of the matter?
Merits of the matter.
How is it not connected to in the same principle as of the High Court, Supreme Court judgment?
Supreme
granting aid, Justice Mishra's judgment is directly on the point.
Lordship, earlier to that, granting aid principle was adopted by this honorable court in Prafulla Kumar Sahu, page 86. It was dismissed. State appeal was dismissed. Thereafter, they implemented the order.
They are asking you,
Lordship,
that the judgment of the Supreme Court is now cleared the position, right? That Justice Mishra's judgment covers the point.
No, Lordship, with great respect.
That's what we are asking you. Tell us.
Lordships, I am salary is released in my favor in regards to 2009 block grant principle. I joined in to 1990. Therefore, 2004 principle is not applicable to us. Honorable Justice Mishra judgment is only on 2024. Lordship, granting aid principle.
1 minute. Your appointment is on 23rd of October 91.
91.
By which time your 1990. 1990 order about granting aid was in operation. The other order came in 94. That's a subsequent policy which is not applicable to you. That's not applicable to you. So therefore, the judgment of the Supreme Court, so they applied the judgment and said the issue is now covered by the judgment of the Supreme Court and reverts the single judge's order. So what's wrong about it? Even otherwise, even if you condone the delay, issue is covered by the judgment of the Supreme Court.
Similar issue is pending here, Lordship.
That is where individual has come or a...
Individuals. Your Lordships heard this matter. I did appear before my Lord.
Show us that. Show us that order, sir. Don't show us that...
Office report.
Show us the order.
Order. Show the order that admitted.
You haven't even mentioned about it in your SLP.
You have not mentioned. That is admitted and tagged. Show that those orders.
The best point you are telling us in the last point. If it is similar matters are issued, why do you trouble yourself and us? Show us that order.
There are 20 SLPs admitted.
Show us one order at least.
Lordship, kindly pass over immediately.
All right, pass over. If you had even at least mentioned it, we would have
You
are not even carrying that order.
Against all efforts, SLP is admitted by the private party, by the state.
Sure, we'll pass it over, sure.
Let's.
This is the order. Uday. 25.
Online? Me? Nobody is appearing.
14% है क्या? Mr. Satish Pandey.
Not appearing.
14% नहीं
No,
ना?
no. Satish Pandey is admin.
Pass out करना.
Item 26.
No, Your Lordships, in this case, Your Lordship, the limited point is, Your Lordship, the rules of the university specifically provided that only the Vice Chancellor can cancel my result. Now, after my result is declared in 2019, Your Lordship, my previous result is withdrawn. That previous result, which is the subject matter continued.
कैसे retrospectively कर दिया है?
2016 was that talk.
Now in 2016, Your Lordship, my result is declared for examination in 2015, which is withdrawn in 2020. And the university takes a stand that we withdrew the result immediately after it came to our notice, which is actually incorrect, Your Lordships.
We'll issue notice.
You oblige. Very good.
Too much.
But a short password will be granted.
So retrospectively withdraw करके fail कर दिया.
Short password will be granted. Item 27. Yes.
अरे, गौरव?
Yes.
Pass over.
Yes, sir.
28.
May I please? There are inordinate delay of 866 days delay, Malos.
No, just.
So far as merit is concerned, order of the tribunal is an
Writ
expert.
appeal, review.
Yes, Malos. Order of the tribunal is an expert order. That is.
Subsequently, High Court writ appeal.
Yes, yes, ma'am.
Thank you. Dismiss.
Lordship, I'm seeking a passover.
Isn't similar matters pending?
My lord, yes.
Will issue notice post alum.
SLP civil number 15127 of 2025.
All right.
Dusty in addition, my lord.
Yes, yes.
Highly obliged.
Oblige your Lordship.
Response are all lectures in the private colleges. Pay revision is concerned, you have no issue because it is
The notice.
It's a fresh matter.
fresh matter.
Lord.
And
Yes, the pay scale is concerned, there is no issue. Fifth pay commission, sixth pay commission comes. And so far as retirement benefits are concerned, like pension, it is between the private management and the workers.
No,
There can be no liability on the.
My lord, however,
1 second, sir. I am arguing. Why are you?
Don't do that. All of you should get over this habit.
There can be no.
Even before the petitioner
sorry, ma'am.
opens the case.
I'm sorry, ma'am.
There can be no liability on the state. Kindly turn to page number 44. That is the first document where, while admitting it itself, we have indicated that. And also,
Your only point is that they are all self-finance cases.
contributory provident fund, they are under that scheme. They have to go under that scheme.
No.
CPF scheme.
Contributory है उनको pension. Is there any scheme to their?
CPF scheme, contributory provident fund scheme is there. They have to go under that. That's what we have indicated in page number 44. Kindly turn to page number 44.
तो मुश्किल हो जाएगा ना तो सबको पेंशन कहाँ सरकार को ही नहीं मिल रहा है आजकल 44 Yes, tell us.
Is a decision has been taken by state government so and so that the teachers and the employees of grant received non-government colleges in state may be provided facility of pension, gratuity pension and commutation facility as per the.
High Court say
Yes. High Court says that we have paid for this one pay commission has come. We have paid it. This one 2 crores grant was paid in 2010. Therefore, we have to. One more aspect, just let me point out. Even the rule also, it was earlier Madhya Pradesh rule. That also specifically excludes the. I will look at the rule.
Examine this. What do you say?
My lord, the letter which has not been put in this petition, my lord, that is High Court had considered 12th October 2010. My lord, somehow a copy is with me, my lord, wherein they state, may I read out, my lord, it is in Hindi. They themselves had said, my lord, that we are for budgetary sanction had come for 4 crores. And from 1st April 2010, fifth pay commission pension shall be made payable. And there is a budget allocation of 2 crores.
Question is, to whom it is payable is the question.
That's right, my lord. And then answer, my lord, Justice Learned Single Judge's judgment, my lord, and then division bench. I read out 3 paragraphs. It is so to the point, my lord, it is being recorded in the division bench order. If your lordships may kindly permit me, my lord.
Yes.
Impugn order, lordships may kindly have that one. Honorable High Court in the impugn order records everything, my lord. And then lordships may kindly see their stand before High. Para 7, para 8 onwards, my lord. Para 8. May I read that, my lord?
Yeah.
Perusal of the petition filed by the respondent so and so shows that petitions were filed by respective petitioner for various relief, but while submission they confined to pension at the revised rate granted by state government as per fifth pay commission. Para 8 of the impugn order also shows that when the writ petitions were pending before this court, the respondent state have subsequently granted benefit of pension at the revised rate to the petitioners with effect from October 2010, which all the petitioners are getting even today. Therefore, dispute before the learned, over the page, my lord, learned single judge was confined only to the entitlement to the pension at the revised rate from the date of their retirement, that is October 2010. Since that, respondent writ petitioners have been receiving at the revised rate. Supposing the petition submits that, since the petitioner were directly in employment under private education, of pension and gratuity ought to have been settled upon the private institution, as is evident from the order dated so and so. With the order dated so and so, the state government is said to have taken a stand that since the teaching and non-teaching staffs would be entitled for pension, they would not benefit of revision of pay scale, and the pension also would be paid at the pre-revised rate itself. This contention of the state government is hard to accept for the reason that liability part of the state government was not in dispute prior to the coming into force of fifth pay commission. The liability has also been accepted by state government at the revised rate subsequent to the order dated.
And with respect to what?
Pension, my lord. That this
Respect to the payment of pension.
pension.
Pension with respect to which institutions, even private institutions.
Private and non. Yes,
Shows that.
that's-
the question we are
They are the 100% grant
Yes.
in school.
Where
my lord, may I answer that? May lordships may kindly see where it is the letter itself which Honorable High Court records, my lord. Just page before, my lord, para 10. Lordships may kindly. With a order dated 21st September 1992, the state government is said to have taken a stand that since the teaching and non-teaching staff would be entitled for pension, they would not be entitled for the benefit of revision of pay scale.
teaching staff of which institution?
Private and non-private,
That.
that's right, my lord. Just before it. 12 again. State Council, on the other hand, opposing the petition, submits that since the petitioners were directly in employment under private educational, the liability of payment of pension and gratuity ought to have been settled upon private institutions, as is evident from the order dated so and so. That was the order, my lord. Now, subsequent to this order has come. With the order dated 21st September 1992, the state government is said to have. So,
In a private institution to seek pension. Shows that.
my lord, this is the document which I have brought.
Judgment
My lord,
under challenge.
Implementation of revision.
1 minute.
I will
after finishes.
My lord, this is the government circular their own implementation and gratuity scheme for aided non-government college oblique in Madhya Pradesh. The Madhya Pradesh, then subsequently Chhattisgarh had been carved out, my lord. So this is the parent document which governs the field. Now, my lord, may I read that the state government says what? It's a secretary order, and in that order, my lord, it is being discussed.
There is no doubt about the fact that your institutions are all aided.
Aided.
Yes, yes.
And
the
it is being
100% aid.
Then
Yes.
they are aided and you are.
100%
That's
grant.
100% grant in aid.
Totally
Salary
governed
is
by the
perfect. Salary is concerned is perfect.
I'm saying that pension is extended.
Let's kindly see.
Pension is extended to aided institutions.
That's right.
Yes.
Of even private.
That cannot be because of the rule position. Yes. Rule, just now handed over the rule copy. It's called MP Civil Services Rules.
That's right.
Kindly go to application. Save as otherwise provided in these rules shall apply to every government servant appointed to civil services post in connection with the affairs of the so and so, who are born on the establishment and not declared as non-pensionable. These rules shall not apply to, kindly come to D, persons entitled to the benefit of contributory provident fund.
No.
Yes. Contributory provident
Yes.
funds are not applicable is one thing.
Yes, and also it is applicable to the government employees. Every government Servant.
Is the civil single or division bench dealt with this?
Page
Lord, this-
467 is the my lord, single
Sir?
bench.
My lord,
What are you showing?
my lord, this, as my learned, my lord, respected, my lord, senior counsel had shown, that is being considered again in the same government order of Madhya Pradesh, and I'll read out that relevant paragraph. The government of Madhya Pradesh in
When is
higher,
that order dated?
my lord, it's 1st July 1989 by Secretary S.C. Mishra, and it's a Bhopal, my lord, 1st July 1989.
They have every document, our state council.
An act has been referred to, my lord.
89 order.
That's right, my lord. And then Chhattisgarh had been carved out.
Yeah, penguin fan. What is that?
Lordship, may I, my lord, I laid hand on a single copy, my lord, and I'm sorry, my lord, I would have that come in the last moment, and Lordship, may.
1 minute.
This is being referred and
So that's there is already a scheme.
that's right, my lord.
Yes,
And
my lord. And it is undisputed
my lord,
that I'm
just a second. Over the page, my lord, third page. Yes, third page, my lord. Second and then third, my lord. That's right. They have now discussed the act, my lord. On the top, they have
The
started
only
with the
thing what-
discussion, and then after referring to all that, my lord,
the only thing what they are disputing is that whether we are entitled for the revised rate or not. We are entitled for pension. It is an admitted position, my lord. Apart from the order, they are
Have a look
pleading
at
with
it. I
respect
think
to
it's
the
not a
admission.
case for us to interfere.
I'm so
Yes,
deeply
absolutely, my
obliged,
lord.
my lord.
Deeply obliged.
Have a look.
I'll look.
Tim, have a
Deeply
look.
obliged.
You just gave it across the board to him.
Even as for the pleading, my lord, it is undisputed that.
I think
that
you already
entitled
implemented
pension-
it.
Yeah,
And
they
I am
admitted
getting
it.
everything, my lord. 80 years plus.
Dispute is only that whether we are entitled for the revised or not.
80 years plus teachers.
Keep the
They all are
question of
frail.
law open for you.
I'm
Then
so
you may dismiss it
Delay,
on the
my
ground
lord,
of
delay
delay.
also.
Delay.
Delay.
Just on delay.
I'm so grateful, my lord. Deeply obliged. Sir, can I have?
Take the copy. You.
Sorry, sir. Sorry, sir. No, sir. No, sir.
Not me.
You have placed the affidavit order. I'm seeking password in item number 31.
But
We'll fix a date.
Yes, we'll fix a
hear
date.
may I just say this? They filed an
We have to hear
affidavit.
these matters.
They have filed an affidavit. I'm carrying the documents, but it'll be better if I put an affidavit in response.
Put it.
I'll file it on Monday, my
Put
lord.
it, I think this is, now the.
Put it
we
for
will
him.
Put it up a.
Final hearing.
Definitely, my lord. Definitely.
Put it up arguments, huh?
We'll file short written submissions, very short, whatever your
Lord,
lordship suggests.
Lordship, in NEET petition 687, 2025,
We
31.13.
will actually, what we will do is, we'll properly hear this matter.
Yes.
Instead of bits and pieces in a
Yes, my
miscellaneous day, we will appeal the special leave granted, appeals expedited,
Petition number.
list in the final hearing list in the month of, we will just tell you,
Yes,
check our
my lord, yes.
existing board,
Yes,
and
my
we will add it up because there is an urgency in this matter.
my lord. I have one request.
My lords, may I?
Can
In
we?
the meanwhile,
We'll file an affidavit in response. But two things I wanted to clarify. One, affidavit in response will file blood within a week. Second thing, Lord, I think there was a plea on that side that the states have to be made parties. That may not be necessary because one state's already party in one of the batch matters.
But it's not necessary, Lord. It's not necessary.
Yes.
But in a health matter, it won't be because the allocation of resources to come from the center.
Policies of the center.
I'll make good that submission, Lord.
We have to pass some direction.
Yes.
My Lord, I'll make good that submission. Give me the note.
Okay,
Give the policy.
on the oral application.
My
the
Lord,
states
that means,
are made a party. Copies of the lead specially petition.
my Lord,
But
they already parties in another matter.
31.4 is the lead matter.
Lord, just a minute. Where is that?
What the appeal
My Lord,
against the High Court judgment.
Avnish Shah, 31.4.
My Lord, if I may can I just point out, in Ratan Kumar Jigyasu, there are already parties. It's a connected matter.
All the matters.
Yes, in Ratan Kumar Jigyasu, there are already parties.
All states.
Yeah, I believe so, sir. That's my
Yes,
instruction.
yes, my lords. I'm the lawyer for Ratnesh Kumar.
Then, we will
All
say-
states are parties.
We will say, which will be the lead matter, Mr. Venkatraman?
31.4.
Not in Ratan
Avnish
Kumar
Shah.
Jigyasu.
That is where Justice Pratibha Singh's judgment.
Yes, yes, yes.
31.4
31.4.
1.4 shall be the lead matter. In view of the fact, Mr. Luthra,
Yes.
in which is that case in which
Lord,
the
that
parties?
will be, I'll just tell you.
In view of the fact.
But it's
that,
Ratnesh
in
Kumar
such
Jigyasu. I'll
a
give you a
case,
lordship the number.
all state governments are made party respondents. Let copy of the special
Lord, it's-
petition, soft copy of the special petition
Lord,
be
it'll-
served on the standing council.
1012. Lord, it'll be CWP 1012 of 2023.
Sure.
I'll just, that's my
Sure,
instruction.
done that.
May I just,
My lords, may I?
Yes, in item 31.13, city 7/2025, notice was not issued, Lordship. Notice be issued in this.
Lord, in 31.5, which is the SLB from Kerala, they've also filed a transfer petition, which is 792. No, that doesn't survive anymore. In fact, it's not on board. I don't want to take a formal order. The Lordship may keep it any day so we can,
We'll
Grateful.
deal with it.
we'll file written submission.
Thank you.
Much
My lords, may I? My lords in
December,
31.3.
not in November.
Whenever
My
you,
lords in, my lords, may I?
he said, he'll indicate.
My
that.
lords in 31.3, 9 children have died.
Whatever, Lord.
Grateful.
In
Only
31.3,
way we realized is to actually take a final call on this.
Yes, ma'am.
my lords, there is an urgency, my lords. In 31.3,
They've taken,
Ratnesh
sir, we
Kumar
know that,
Jigyasu.
we know that. Thank you.
9 children have died, my lord. Right, my lord.
32.
May please, my lord. Your lordships have very kindly given us permission to file some additional documents in this matter, my lord, which we have, only to show, my lord, that the 7/1/2020,
What was the other case which we decided?
your lordship decided, my lord, on citing criteria, and your lordship said, my lord, that
There we have indicated,
there was some private malice.
that's the only thing.
There was some private malice. My lord, I'm not alleging private.
Read the judgment.
I'm not citing private malice here.
The name of that case?
My lord, Arun Kumar Sharma, your lordship, my lord authored it, my lord, Arun Kumar Sharma versus State of Madhya Pradesh, my lord. My lord sitting with his lordship Justice Bagchi. And that's, my lord, dated 14 July 25. 14 July 25, my lord.
Read that judgment carefully.
Yes, my lord.
Read it carefully, not like. If you read it carefully,
It's malice.
they are wrong. No, it's nothing to do with malice. Show us that once.
Right here.
Now,
My lord, mine is a marked copy, my lord.
No, doesn't matter. Just give it to us.
I'm so sorry.
We wanted to write on this. But that malice was an issue there.
Yes, my lord.
अगर अपना देश में
Should we have this remanded back to the NGT for second consideration of it?
listen to this thing, right?
Okay, better. Because is better.
We can remove them.
That's what I'm trying to do. This time I'll tell you there we'll succeed. I'm 100%. So he's a little squeamish. There's a little bit of a problem. But Yes, yes, largely on facts, my lord. My lord, may I humbly submit something that may be, my lord, palatable to my learned friend, my lord. My lord, the tribunal actually has not had the occasion to consider a very significant factor here, which is, my lord, seems to have weighed with the tribunal, which is the high water table and whether there could be leaching. Because, my lord, that issue was never flagged in the OM. It came up for the first time in the rejoinder. My lord, their rejoinder in one paragraph, my lord, brought that out, and
The only point is that in our country, to say that we can of course set up a petrol bunk where there is no residential areas. But once we say that the residential areas will be those which are authorized residential areas, you will hardly get any place because the country is filled with unauthorized. So just because somebody is unauthorized, you can set up a polluting industry.
no, no. Therefore, would your lordships therefore consider the tribunal should have had the occasion to see these documents? It can be remanded back. I'll tell your lordship why.
The scheme and other things. How do you
7/1/2020, my lord, comprehensive guidelines. If I'm in breach,
notice, right?
No,
I'm grateful. I'm grateful.
it's not issued notice.
Yes,
In fact,
my lords are saying, will,
not inclined to issue
my
notice.
lords are
Why
saying,
we are inclined, why we will lay down this clearly.
Your lord,
the law needs to be laid down. I completely, my lord.
No interim order, of course, you have not granted an interim.
No, there is. Your lordship may, my lord, nail it down for final hearing, my lord. We'll finish this because it's a matter because Justice Pardiwala's judgment is also there on this, my lord, on 7/1/2020 guidelines. My lord, that judgment your lordship will find is Indian Oil Limited versus VBR Menon, and that's 2023 7 SCC 368. My lord framed the question but didn't answer it, my lord. So it's open to your lordships now. My lord, 2023 7 SCC 368.
in fact, they
The question is squarely framed, and my lord, then
answered in our favor.
no, I'm sorry. Your lord.
Your lord,
I'll show it to your lord.
Next.
can I just point out one thing, your lord?
Just notice, that's all, nothing.
I'm very grateful, my lord. I'm very grateful to my lords, my lord.
Because your lordship said about unauthorized, actually there are 940 districts in Kerala and only for 12 districts they have zoning. So that means only 1% Kerala's land
Have
was
to write
zoned.
down.
Abutting the state high,
Then it's carte blanche for them, your lordship.
abutting the highway, my lord. What,
Designation.
Can't be, but at the same time, there should be petrol bunks.
That's
where
right.
people are driving on the.
it's abutting the highway.
Provided you
And look at the safeguards, my lord.
Postpone.
My lord, your lordship will find the safeguards are immaculate. I'm grateful, my lord. Deeply grateful.
addition, not in substitute.
Lordships on item 33, lordships had sought for status report
Lordship,
from
I'm
the
requesting
pollution.
for password.
But that has come, we thought.
Lordship, all the status reports have been filed.
Status reports have all been filed, your lordships, and in most of our cases, at least in my two cases in which I'm appearing, it is clear from the status report that there is no violation. Your lordships will take civil appeal 10236 and 37.
No, but otherwise also.
Civilizer position in 33.2.
All matters.
What do you want us to do today?
Your lordships, they have to be disposed of.
One of you speak.
Covered by a decision of a coordinate bench on the second point. This is all, these are all cases where action was directed to be taken against us on the basis of a report in some other matter.
Who is appearing? Is Pollution Control Board? Yeah.
Yes, Lord.
Lordships,
I'm requesting for password. Mr. Mishra is Legan. Other board.
Password.
today, your lordships, my only submission is that in,
Password?
yes, I'm just making a submission while Mr. Mishra arrives, your lordship.
Why?
Lordships,
Yes.
just to apprise your lordships, lordships had asked.
It won't happen today. No, I'm asking you.
Very well.
You want an adjournment or?
No, not at all.
Password. Happened to the mediation?
My lords, this is a matter.
Sir, given me liberty to file counter affidavit on the last occasion. I filed it yesterday.
2 weeks. Stop.
Sorry, 2 weeks. List after 2 weeks.
Excuse me.
35.
Lordship, in 35, I have 10 minutes yesterday.
10 minutes.
Lordship, have it on a date.
We haven't received that rejoinder copy.
I have emailed. So give me your email ID. I'll give it again. The person was in hospital when they are claiming that the service was made.
So there was no actual service, and he retired. He was isolated in COVID. So there was no way they could have served him.
This is only on the principles of natural justice. But otherwise, disciplinary
Our main contention is the proceedings could not have been retired.
What stage are they?
No show cause was issued.
As of today, because your writs are dismissed, have they proceeded with it?
It is going on, but no order.
They're asking you, has it, what stage
No.
is that?
No order.
You're participating or not participating?
Yes.
He's participating. We'll ask them to dismiss.
Lordship has observed that we should participate without prejudice. We are doing that.
Participate, we'll say that. It's only
Lordship let this rejoinder come on record. Lordship may hear it.
2 weeks. As the rejoinder has not come on record. Next.
Would Lordship fix a date?
Call it.
Great.
36, Your Lordship, the parties have come to a settlement. May I only please recorded they are withdrawing all the matters with the
So
consent.
we'll dispose of in terms of
In view of the High Court
Yes, my lord.
order as well as the consent terms mentioned here in Your Lordships. Para 3, Your Lordships.
It is evident from the order dated. From the order number so and so dated of the High Courts. So the parties have arrived at a settlement in view of the development, in view of this development, especially petition is disposed of. Date of this.
Lordship, this is an after this matter. Your Lordships have filed a compilation yesterday. Your Lordship may be pleased to take up that compilation. Your Lordship, I'll just briefly state the facts. Your Lordship, the respondent number 1 in a private school. Your Lordship, not on on the identical facts, but Your Lordship, there is an interpretation of grant in aid which is pending, but that is not similar on facts. Your Lordship, what has happened is the respondent number 1 is stated to have been appointed as a peon in a private school, which was in 1995 recognized. Yes, Your Lordship, there are similar, I understand there's a delay. There was a delay before in the writ appeal of 173 days. Your Lordship, this Honorable Court has similarly remanded many matters. I have placed them on record from 86 to 107 of my compilation. Similarly, 100, 155 days, 120 days, they have remanded it back for consideration because in this, there was 173 days delay in filing of the intra-court appeal. And Your Lordship, in this, Your Lordship may know 2000, the cause of action arose. He files a writ petition in 96, the cause of action arose. He files it 4 years later.
I'm appearing for the respondent.
Your Lordship, in this, Your Lordship, there are the judgments of this Honorable Court where such reliefs is ex officio stated to be illegal and not in terms of the GIA order. May I just point out those judgments? That is at serial number 5 and 6 of my compilation.
Keep the question of law open for you.
Your Lordship, but in this case, he was appointed illegally. He was not a recognized peon, and it was directed that he be paid grant in aid as per the order. Your Lordship, the grant in aid order does not permit.
The facts and circumstances of the case, we are not inclined to interfere in exercise of our jurisdiction under Article 136. The question of law raised by the counsel for the petitioner is kept open for being considered in an appropriate case. In this view of the matter, specially petition stands dismissed.
Please, Your Lordship.
Chalo. आज उड़ीसा के मैटर तो
this matter to be listed on NMD.
Yes. There's an order.
NMD.
Yes, my lord, redacted that earlier also.
There's an order to that effect also.
All right.
May I just request for some early date because MSCME, my lords, we are already
It has to go before the CB, right?
My lords, we are ready to go before the Facilitation Council as directed by the High Court, my lords, because according to 18th we have not been followed.
Await the
No,
CB.
my lords, slightly different issue. I'm not on the filing of writ petition, but the manner in which the writ petition has been entertained, it's a complete wrong interpretation of MSME Act. That is what we had persuaded your lordship to issue notice. The hyper-technical approach has been taken by the High Court while interpreting MSME Act. So in my submission, it should not take too long, my lords. CB is a different issue, my lords, about maintainability of writ.
Otherwise, we
I'm
are
not on
covered
that
by the
matter.
Constitution bench clearly, my lords, because the finding of the High Court is that if there is a procedural infirmity, then a writ petition is maintainable. So,
For disposal, file and disposal.
I'm so grateful, my lords.
I'm obliged.
Well, 39, I find from the office report that the committee's report has been submitted to your lordship.
We filed
At least I am not in possession of that. I do not
We
know.
filed it. I could have given, otherwise we have, well, if your lordships have that, it's filed on 4th of August 25.
You're for Noida, right? Oh, you're for...
No, my lords, your lordships had
I know.
directed us to carry out a joint inspection.
So now
Noida Authority, my colleague.
No, that report is there now. We have seen your report.
Yes, my lord. So
So
they
the-
have removed it. They have,
Rather-
at that point in time, there was temporarily, the construction demolition waste was there in the green area. The wall was broken. Yes.
He's saying
But-
in your favor. I don't know what.
No, why I came here was this, my lord. Very short, one sentence point, my lord. The court, my lord, the NGT slapped us with a fine of 5 lakhs, saying on the principle polluter pays. Now, my submission in 3 affidavits before the NGT was not a
The
tree
amount
has.
was to be given to whom?
I'm sorry, my lord.
The 5 lakhs.
They imposed it, my lord. But then your lordships did not stay that. Your lordship said, all right, give it to for the timing, give it to the pollution control board. But the question was, my lord, when I have not caused any pollution, where is the question of slapping me with the fine? Not a gram of C&D waste was put there. Not a tree was cut, not a shrub was cut.
It
We-
was to be
we-
paid to the UP Pollution Control.
UP pollution board. ठीक है.
So therefore, my lord,
Payment is not much, 5 lakhs.
my lord, may not be, but then there are several other petitions which are pending.
Now in terms of your affidavit, correct?
So, my lord, there is no finding, at least what
There is a direction. Doesn't matter, Mr. Vivek.
Wait, it does, my lord, in my respectful submission, it does matter to us, my lord. There is a finding, then the principle will be invoked in every other case.
We'll see.
What have I done, my lord?
Second-
There has to, my lord,
Just wait.
2nd May 25 is the order where your lordships had
29.
directed us to carry out the inspection.
For order. 25. है ना? 25 ना?
your lordship now also have the order of 30th of July 24, my lord. Your lordship's own order.
We will also see by the order impugned before us, the National Green Tribunal directed as under. Stop. ये quote कर लेना impugned order को relevant portion. It's 16 May. This original application is filed by whom?
By one Sanyogita Singh, who has, my lord, remained absent before your lordship's court.
Okay, ऐसा देखिएगा. An original application was filed by the respondent alleging that what is C&D waste?
My lord, construction and demolition, they said you are going to establish a plant over there. That's the allegation.
Plant has been set up in a green belt in violation, which is in complete violation of 2016 rules. Disposing of the original application, the National Green Tribunal passed the following order. Paragraph. While admitting the appeal, after admitting the appeal, by our order dated 2/5/2025, we directed a joint constitution of a joint committee comprising of the Central Pollution Control Board and Uttar Pradesh Control Board or Pollution Control Board to visit the site and submit a detailed report about the statutory compliances by the appellant. Paragraph. In compliance of our directions, the joint committee has submitted its report on 4/8/2025. Which copy of the I have how many pages is this?
The report itself
The
is 6
report also.
pages. Rest are annexures.
The report as it is extracted here and below for ready reference. Paragraph unquote करने के बाद, in view of the above clear findings that Noida has set up the temporary CNG waste site.
Lord, I'm sorry for interjecting, Lord. It was never set up. It was never set up. We only proposed.
You want to file objections to this?
I would, my lord. I would, my lord. Your lordship, my lordship, affidavit to that effect.
Okay, we'll ask.
Let me, my lord, put it on record, my lord. Otherwise, I'll be prejudiced, my lord.
Now, what remains in this? The information. Okay, all right, you file your objection. Inspection to observe that no temporary construction is informed. How can he wriggle out of all this? You file your
I will, sir. Because
then we will examine it in detail.
certainly, my lord, your lordship would,
might
my
be
lord,
invited
because
something.
what I was submitting, my lord, just one sentence of your lordship's own order, my lord, 30th of July, your lordships had recorded my submission that there has not been any pollution as such, my lord. Please have the order of 30th of July, and that
It's not merely a case of pollution in every case.
my lord,
Non-compliance.
non-compliance of what I asked
Strict
myself.
compliance.
Yes.
Strict compliance of what pollution related in, it's a no tolerance zone. So
It
therefore,
is.
you
It
file
was
your objection.
I will, my lord. I'm so grateful for that, my lord.
ऐसा draft बना के रख लेना, तो next time dispose of कर देंगे.
Let me put it on record, my lord. Let me have a look at it. The NGT also did not find, my lord, we have dumped any CND waste.
In the meanwhile, appellant may file its response to the joint committee.
I'm so grateful, my lord.
Come back. Will
Much obliged. Much obliged. Grateful.
the letter there, right?
Your Lordships, I appear for the respondents. I'm seeking for a short passover.
Again, a delay. High Court, this, how much is the delay? Who is for the
Your Lordships, 198 days by the state of Jharkhand.
UGC school charges
Item 41, the respondent 4 has passed away. I need the details to read the LRs of respondent 4.
Doesn't matter what it lasts. How much is the delay?
198 days.
Just for one item.
Delay, my lords, was 198 days.
190.
Now, my lords, the High Court, if your lordship sees the impugned order, my lords,
Your Lordships, may kindly pass over the matter.
onwards,
Wait a minute.
only refers, my lords, to judgments of your lordships. My lords.
Is it really worth for you to pursue this matter?
My lords, otherwise, my lord, our case is, my
The
lords.
scale is to be given, that's all.
Yes, my lord, but that has to be, I mean, it has a checkered history, my lords. There was, my lords, that Justice S.C. Agarwal committee, which had gone into this, my lords, and there were various categories. Now, my lords, what the High Court does, my lords, only on limitation, my lords, extracts judgments of your lordship's court. Similar judgment, my lords, set aside by another court here. Same judgment of this honorable judge.
If you want, we will send it back.
Yes, my lord, let the High Court take up on
Subject to what you say, we'll have to.
Lords, I had filed, I mean, I'm a retired professor. There are like 7 applicants are there. Lords, I had 7 applicants. We had filed an IA for impleadment in this matter.
Impleadment?
Lords, let me just come to this point. In fact, we had filed a writ petition in
The High Court.
In the High Court.
Correct.
We got a favorable order. Thereafter, the government filed a recent order, which was a little dicey. And we filed a contempt petition that, they are not implementing the High Court's order. Thereafter, now this matter has come up, and that's the reason why we filed an implementation application. It's not like, all of a sudden we came here.
Huge liability of 5 crores, my lords.
That matter.
Well, Lords, we were entitled.
So he will not be entitled to, is the decision of the university. But now we have to, why the university took a decision? Why is the government here?
Sorry, my lords.
Why is the government here?
Because ultimately the money has to go from us, my lords. 560 crores, my lords, more than 560 crores.
Lords, during the year 2005, we were getting to the revised payment. We were getting.
What we will do is, instead of, give them one chance before the division bench will condone the delay and then restore the writ appeal.
And carry it on.
That's it. Okay.
Will also kindly observe this, that, I had filed an.
We'll ask the writ appeal to be disposed of expeditiously.
Very well.
And the IAs that we had filed, one IA got already allowed by your lordship.
Saying?
No, the notice was issued and they were, supposed to reply to it. Yes, yes, IA number 29076.
What was the prayer?
Paragraph.
Oh, you were supposed to.
Leave granted. The petitioners, the respondents of petition challenging the letter of the registrar of which university is this?
Sidhu Khan.
Yes.
So and so dekh lena. Was allowed by the learned single judge of the High Court. And there was a single judge directing absorption and payment of fifth UGC pay scale with arrears. The state challenged the said order by the learned single judge before the division bench of the High Court. However, the division bench, by the order impugned before us, dismissed the writ appeal on the ground of delay. Having heard the learned counsel for the petitioner and the respondents, in view of the fact that the issue arising for consideration touches upon the policy of the state and also policy of the state having substantial financial implication, we are of the opinion that an additional opportunity must be given to the state to contest the matter before the division bench of the High Court. Paragraph in view of the above, we allow the appeal, set aside the order passed by the High Court, and remand and restore the writ petition to its original. LPA.
Let us all the IAs also be.
We make it clear that we have not expressed any opinion on the merits of the matter. The parties before the division bench will be entitled to raise all such contentions as may be permissible in law. We would also request the High Court to take up and dispose of the writ appeal expeditiously.
Grateful.
What do you want?
Since we have filed an IA, we also be grant liberty to approach the High Court. Sir, we can file maybe an appropriate petition or we can implead because we are all retired.
Just to say, no, don't say that. If any party moves an application for intervention
or impleadment,
the same may be taken up and disposed of on its own merits.
A time-bound manner we fix because why I say this is one of the respondents has already expired. They're all
already said it. Expedition.
Sometimes, if preferably within certain time period, if that can be indicated.
Say that to the High Courts. You have to respect their due.
Grateful, man.
The word is enough.
I bow.
Please, Lord.
Sandeep, how many times you will come for this? So many times we have not given you a relief.
No, this has been adjourned at the instance of state because
so many times
March 25, your lordship's orders.
You are in this, Mukund?
Yes.
That's the item?
Yes. And so the state who has to take instructions if the petitioner can be accommodated or not.
At the last.
Who are you appearing for?
The management, the college.
No, there's no post available now. Only respondent number 5 has already been given that post. So there's no post available to even accommodate the petition.
So I have placed document.
We will decide it.
So I have placed document received under right information act. There are 5 sectioned posts and 4 have been appointed.
You are supporting him.
Vacancy 1.
Lords, we don't have any grievance if they give us a sanction.
There's my instruction.
There is still one
no
vacancy
post available.
There are 5 seats vacant, posts available, out of which the appointment is on 4. The 4th appointment
Qualification is one issue.
Yes.
Yes, Milad.
Qualification is an issue as of that particular date.
So
then you worked for a long time.
For almost 19 years and approval. Even today, even as on today, I am employed.
We will allow your case. Okay, you make your form. We will hear you then. We will hear you.
My lords.
Want to argue today or?
I am ready today as well, my lords.
We'll have it on an MND or maybe next week, Milad.
Wait, Tuesday laga de.
Very good.
We'll dispose it of.
My lord.
Grateful.
Make a short 1-page note.
No, I already have it, my lords. I already have it today as well.
Right. Then
my lords. Obliged lordships.
Please. This is that cricket match, my lords. My lords, pursuant to the last order, my lords, we have filed an additional affidavit
My lords, I feel that that would take care of all the concerns which were expressed by the learned amicus as well as my lord. Page number 12, my lords of my.
We'll hear it.
Lorships, in fact, there's just one thing which I want to bring. Lorships, after the filing of the affidavit, which was done on 4th of November, the respondents have served a couple of orders.
Can there be some kind of an interim measure before we finally dispose of the case?
Difficulty today is that the 176 members which they are asking as a life member, there's an order of the High Court which they have not brought to attention of this Honorable Court, where the High Court has directed certain investigations. The High Court says that on record, initially only clubs were members, and they are trying to bring in 176 individuals. There's a High Court order
Members are from
which they have
1998
challenged,
onwards.
which is pending.
All
My lords,
The difficulty is that how will the court today, this
my
court
lord,
decide?
this is something which is every time they come up with some new thing, my lord. My lord, since
As and when-
1998, my lords, these are the members since 1998.
To argue, but then we will see. But this is exactly what we were trying to prevent.
That's right, my lords. Therefore, I have,
rectify
my lords.
institutionalized sports.
Yes, my lords. So therefore, my lords, page number 12, my lords, may kindly see. My lords, just. Yes, my lords. I filed that additional affidavit. My lords, a short affidavit. I'll make a note also.
Lorships, I have filed a note. I'll find a detailed note again.
Your Lordship.
Yes,
Some
Your
very
Lordship,
good
I've
points.
seen it. I've seen it.
You've seen it, that latest one, which is.
Yes, Your Lordship, I've seen it.
You have to look at it.
I'll add to that.
My lords, and all these orders which are being referred to may be placed on record.
Your
because
Lordship, we'll place it.
all
on-
these orders which are being mentioned today, my lords, let them place it on record.
We'll let it have an affidavit.
Additional documents may be filed with us in the meanwhile. For date, they then, for Tuesday.
Your Lordship, maybe a response may be permitted to respond to what they have stated in the additional affidavit by way of an affidavit.
Do that.
Because can I pray for a shorter date because the whole election process has been stalled there.
Any matters are being decided.
That's the problem, my lords.
The whole board is fixed up for final hearing. We did, they then,
We're grateful.
Much obliged.
Much obliged.
This matter, the notice has been returned unserved, my lord. Let it be served through concerned police station.
It's not come. Tell us, did they file an undertaking?
I have to check because it is there is no rule to supply that copy to other side, my lord. But it kindly see the order, my lord. Page 12.
File खोल के देखो, undertaking file हुआ है नहीं? Okay, we'll keep the contempt pending.
Right, my lord.
We'll clarify that you will be entitled to execute the order. And we will take that, you will take the support of the police. Okay?
Very well, please, my lord.
Okay. Pending disposal of the content petition, we make it clear that the petitioners, right? For non-complaint, the petitioner will be entitled to execute the, which is the eviction order.
Eviction, yes, my lord.
Execute the eviction order and take possession. Full stop. The petitioner will also, okay, the law enforcement authority shall cooperate and ensure that the petitioner is put back in possession.
Very well.
Give a letter, ask the ensure that. Which is the executing court?
It would be at
Pending disposal of the specially petition, the content petition, we direct the executing court to ensure that the petitioner is put back in possession.
It's a district court at Bhimavaram, third additional district judge, Bhimavaram.
Is put in possession in execution of the judgment and order dated so and so, which had become final.
Yes, my lord.
That become final by virtue of the dismissal of the specially
petition. Very much.
Then let's see after that if they come or don't come.
Obliged,
Take
my
possession.
May it please, my lord.
Your lordship.
Please, your lordships.
45 is
Yes,
a
sir.
batch of
Your lordships,
45 is a batch of NEET PG matters because some of them are legacy matters.
One question is answered, the other question is left open by Vikram.
That's right.
Your lordship.
Why is it coming before us?
My lord, before Justice Pardiwala.
Sorry?
It was
Pardiwala.
Now before your lordship, but we don't know why.
Milos, in fact, on that day, Milos, they had withdrawn a writ petition with similar prayers. After hearing it for some time, the number is 959 of 2025.
Who has withdrawn?
Milos,
Similar writ petition.
one of the petitioners,
Batch of petitions.
with same prayers.
Withdrawn, but the issue still remains.
Milos, they all argued it.
Was in relation to Milos double shift. That is now resolved by your lordship.
In fact,
Justice Vikram Mathur. Now, the other issue is the non-disclosure of the questions.
It's a policy. What is your policy?
Milos, in one of the writ petition, Milos, we were not a party.
Don't go on technicality, but
Milos, I'm not going on technicality.
tell us with respect to the answer key, what's the policy?
Milos, our policy was there is a non-disclosure agreement they get into in our NEET PG bulletin. Milos, they agree. They will not ask for revaluation. They will not ask for question papers and answer keys. Milos, the reason being, Milos, we are at the postgraduate level. And so, Milos, the questions are very, very limited. Many, I don't want to say, but Milos, many of these petitions are being fueled by the coaching centers. Because Milos, get the question banks. Milos, the standard of education will be diluted.
Your Lordship, just one second,
Can see through, there's no difficulty. We have recently, so far as Union Public Service.
UPSC, my lord, recently passed.
Passed an order, amicus suggested.
And there they agreed also. Yes.
What she's saying is absolutely right.
May I-
because
may-
the
yes.
scope for super specialities, the questions will naturally be limited.
Yes, Milos.
So, and then the number of persons taking them also will be very, very limited. They are not a mass.
And Milos, this is not mathematics. Milos, this is not mathematics where questions can be asked in 10 ways.
Just one.
Milos, if we...
What is the existing policy?
Yes.
Milos, existing policy is, Milos, in our bulletin, when they take an exam, they agree. They will not ask for revaluation. They will not ask for question paper. They will not ask for answer sheet.
May I just say one thing? Just
However, your lordships, however...
And what you have told us is an estoppel. You have not told us what the policy is. What is the policy?
There is no.
Milos,
Why are you interrupting?
Milos, the policy is this only. Because of the limited question papers, these question banks are...
Formulated anywhere.
Yes, Milos, it is there, formulated.
Where is that formulated?
Milos, we have stated in our affidavit, Milos, it's as per our instructions. Milos, we have put our policy in the bulletin. That is our policy. That's why, Milos, I'm again and again referring.
I'll just take a minute.
Milos, just 1 minute, allow me to speak. Milos, our difficulty is this, why we are, Milos, opposing it.
You formulate your policy properly, saying that in view of...
Internal instruction.
In view of...
Milos, our internal instructions are there.
That's what...
That is the policy, Milos. So Milos, so that they know, we put it in the bulletin also.
We are asking this. Have you applied your mind what the requirement of transparency is and to what extent such transparency in comparison to the kind of examinations that you are conducting will have to be in the form of some kind of a measure. It's not a same rule which will apply across the board to anything. So far as NEET exams for PG is concerned, what could be the transparency policy? You reflect and file an affidavit before us.
Milos, we filed an affidavit.
That
We
is-
filed an affidavit.
Your affidavit indicates that they have.
Milos, may I submit one more thing, Milos? Milos, but what happened, Milos, on 29th of April 2025, a petition came up before your lordships. My policy for MBBS is different or same?
MBBS to alag.
Milos, please. Milos, may I have the
Will
petition?
be happy with your,
Please, Milos.
unless you show us
Yes, Milos.
what right.
Milos, may kindly have 45.8, item number 45.8. Milos, may I also bring to your lordship's notice one more thing? Milos, this is significant. Milos, however, what happened was on 29th April 2025, a petition had come up before your lordships. We were not present, and Milos, this issue was not germane to that petition. However, Milos, we were directed to Milos, the directions were issued to Milos give the answer sheets. So, answer keys, sorry. So, Milos, after that, we have complied with that order.
No.
Because
Lordship,
Milos, how?
Don't interrupt.
Humble apology.
Milos,
Some discipline. Some discipline.
No, apologies, Your Lordship.
So, Milos, we have complied with that order. We have on our portal, by using their ID, application ID, they can go to the portal and see, what can they see, Milos? What was the ID of the question, which is number 1, number 2, all question papers, questions in the question paper. Which one was the correct option?
which one was exercised by them, and what are the number of marks they have got. So, my lords, that we have complied with already. So, even though, my lords, our stand on it was that.
Well, just give me one minute, my lords. Yes. Now, please have a look at page 41 of the.
Well, anyway, yeah, see.
Yeah, yes, just what is the problem?
We'll direct you, okay, not like that, you'll have to, this is what is called?
NEET
National
PG.
Board of Examination in Medical Sciences will file an affidavit indicating in detail the policy decision with respect to provisioning answer keys. What exactly is the prayer?
My lords, in fact, in my matter, we have challenged this after my lords. This is what I wanted to point out, my lords. After my lords order, yes, please have a look at the prayer. We have challenged, in fact, their notification, my lords. If my lords would have a look 45.9, 21/8/2025, my lords. They should first one notice, which according to us was all right. Which
Detailed affidavit indicating the policy decision and the basis. Policy decision with respect to.
In pursuance to the order.
Made in the writ petitions.
Yes.
And the reasons for that. The
Yes.
affidavit may be filed within 3 weeks from today.
My lords may specify in pursuance to order dated April 25 of my lords.
Lordship's consideration. My lords, may I submit? My lords, the policy is set out in our internal instructions, and that is what we have stated on the affidavit we have filed. We have stated it in detail. Please.
Internal instructions. But the paper book.
Because internal instructions are not attached, but we have put it on affidavit that this is what we've been following for NEET PG.
You bring those internal instructions. We will have a look at it. Post after 2 weeks.
Please.
We will have a look at it. If we are
Your Lordship,
satisfied, we will leave it at
Your
that.
Lordships may kindly consider the basis of our resistances that, my lords, the question papers are very limited. This is science. So, my lords, in mathematics, you can ask one question 10 ways.
That point.
So, my lords, what happens is,
We are with you on the point.
so, my lords, from all over the country, we have experts who make these question banks. They don't have a copyright on it. Copyright becomes that of the examination conducting body, that is us. And, my lords, if we start disclosing the question papers straight away that this is the question, this is the answer, my lords, the standard of education will be totally diluted. Because, my lords, in 2-3 years, they will have all the questions.
We will examine that argument.
In fact, after considering everything, my lords passed a detailed order that there should be transparency.
That's the reason for us to appreciate that you stand on a different footing. We want to know the reasoning because transparency is an important thing, but it cannot affect the integrity of the examination.
Please, Your Lord.
We will see if your contention is right, and to that extent, we will.
My lords,
Yes, sir.
Right, sir. We will see that.
My lords, I'll have to take instructions on this.
Post after 2
Whether, my lords, we have put it in that manner as your lordships are asking. Because, my lords.
Then you put it in the affidavit.
Yes.
My lords, we will do that. We will do that.
Your Lordship, kindly allow me to submit for the next year. That's all. And not
Post after 2 weeks.
motives that are being.
My lords, yes, my lords.
3 weeks.
Your Lordship, kindly allow me to submit. Your Lordship, I am appearing in the Aditi and others, the lead petition and item number 45.8. We have also raised several discrepancies in the result, Your Lordship, where we have alleged that there is.
We are not going to get into individual.
Your Lordship.
Individual, nor have we done it in any of the case. We are only confining to the principle of transparency, whether to what extent it can be applied to NEET PG examination. That's all.
Your Lordship.
We will
Your Lordships.
If we are in exams, we are not going to.
Your Lordship,
get
I'm-
into the facts of any case.
In fact,
Your Lordship, we are not challenging the exam. We are not asking.
Your lordships have directed me to state the internal policy. My lords, I must say, my lords, very candidly, we may not have it in that manner. So, my lords, tomorrow they, my lords, file petitions after petitions and contempts after contempts. So, my lords, your lordships may kindly clarify whatever we follow, practice, that we will put in affidavit.
2 weeks to enable the National Board for Examination on Medical Science to file,
Because we'll put our stand.
So and so, to indicate in detail the policy the policy, that's all. Don't say anything.
Your Lordship, one last
Obliged.
submission, Your Lordship.
Obliged.
In writ petition 45.8, Your Lordship, there have been discrepancies which we have pointed out. One of the discrepancy being that immediately after the examination,
Writ petition will be dismissed if you mention even one more time about discrepancies. We are not concerned. We told you. We are only seeing the policy, that's all.
Your Lordship,
Your Lordships,
one,
would your Lordships consider saying our stand or procedure, my lords, because we don't have a written policy as my instruction.
Your Lordship.
My lords, that
kindly
will
allow
be for future,
some-
but my lords, for
Now, all of you just adjourn by 3 weeks. Next.
my lords could just say policy oblique procedure, my lords. We would put it.
Lordship 45.11, Lordship, that's the last writ in this batch.
Next.
May notice be issued on that writ, Lordship.
Your Lordship,
Last writ on the batch.
one request. I have filed an application for
Just one
tagging
second.
40.8.
Okay, detag.
45.11, Lordship, if notice be issued because the batch matter, it was before your Lordship. Grateful. Thank you.
Obliged, Lordship.
Number 5.
May I please, Malaj? I'll just pass on one note, Malaj.
What is this, Mr.?
Well, this is a few allottees of a particular project, particular building, where the same project, same building came before this honorable court. 3 judges made it very clear by defining all the allottees in 2 categories.
32 petition.
Yes, Malaj. On the day one, it was made clear, Malaj, it's only that the order of this honorable court where 3 judges have taken a view that the 2 class of allottees are split in 2 categories, where after examining everything about the project and dates and this, where they said that the people who were offered possession in 2019.
You said that judgment, right?
Yes.
Sanjay.
And it's not a fresh matter. It's after notice matter. State has not.